Okay. All right. Well, hello, everybody, and welcome to week 2. I hope everyone had a good Thanksgiving, a nice restful long weekend, and are ready to get the week started. All right, so we'll just get into it. So week 2 is Provincial Court Registries and Rules. So moderators today are both myself, Jennifer, and Rachel. Our presenter is Abisola Omoteo. Okay, so just some refreshers. So first do the land acknowledgement. So we just want to acknowledge that we are doing today's course on the unceded territories of Musqueam, Squamish, and Tsleil-Waututh nations. And then just a quick reminder about what AC Friends of Court is about. So again, it's a nonprofit organization that began in 2011 with its first legal shop being held at the Access Justice Centers located at 800 Hornby Street. Our legal forum workshop helps British Columbians access affordable legal help in a bunch of areas of law. Presently, we have approximately 45% of our clients are family law clients, and AC Family Law School is the first program of its kind in BC. And just again to acknowledge some of the people that have helped us form this school. So we have Kylene Wong of Blacker Groper, Don Batista, our executive director of AC Friends of Court, Dana Cornwall of the National Self-Represented Litigants Project, and Andrew Pillier of the National Self-Represented Litigants Project. And we also want to acknowledge some of the work that is adapted from resources that were given by the Justice Education Society, the National Self-Represented Litigants Project, and Legal Aid BC. So again, just to remind everybody about legal advice versus legal information. So as we talked about last week, we do not give any legal advice. And again, I'm just going to go through and remind everybody about the difference between legal advice and legal information. So again, legal advice is answering a question or providing information that is specific and directly linked to someone's legal case. So for anyone who was asking questions last week about their case, if it were to be answered, it would be considered legal advice, which we cannot do. This course is for legal education only. Legal education is information legal information is answering a question or providing information that is more general, not specific or directly linked to someone's case. So when you're asking about your case, how do I, for example, again, about how do I, I'll move, sorry guys, I'm having a fumble today. So I'll just give the examples again. So my ex says that because I moved out of the house, I'm no longer legally entitled to the rights of the house, nor will I receive financial compensation from that house. Is this true? Answering that is legal advice. General information is, how do I start a court case in provincial court? Okay, well, here's some forms that could help you start a court case. But it's not telling you what your legal rights and obligations are in that case or in that court document. And some, Rachel?
Yeah, so housekeeping, just a reminder that all of the session is going to be recorded and we will email it to the registrants after the fact, so probably by the end of this week. If you haven't already sent in your participation agreements, please make sure to do so and just keep yourselves muted and video turned off during the entire session today, just for your own privacy. And all the questions you can put into the chat box. But please keep the details of your case private, only put in general questions, just like Jennifer went through. And just ensure that you respect others when communicating. Oops, sorry. Okay, perfect. And then you can send the questions to our info at Litigant School BC. Is it .ca or .com? I think we went through this. I think it's .com. Yeah, perfect. Thank you. So we today, yes, okay, please respect speakers. And today we have with us Abisola. She's a family lawyer at PGS Law, where she joined the firm in the May of 2020. She obtained her law degree from the University of Cambridge and holds a Master's of Law from the University of Toronto. Abisola currently represents clients in both Supreme Court and provincial court proceedings and focuses her practice on family law and child protection law. And then in her spare time, she loves to travel and cook. She speaks Spanish and conversational French and enjoys experiencing different cultures. So thank you today for joining us. Our week 2 objectives are going to be understanding the different types of provincial court registries and their requirements, understand the flow of the provincial court process, gain knowledge of the different court forms you may use to start your court action or initiate a hearing, understanding the different types of hearings a party may be expected to attend and how they work, and then understanding some of the more commonly used BC statutes in a provincial court family law case. And just an overview of our outline, and we'll have a question and answer session at the end. So I will now pass this on to Abisola. Thank you so much.
Thank you, Rachel, and thank you, Jennifer. Thank you, everyone, for being here tonight, this evening. So, as Rachel and Jennifer have mentioned, I'll be speaking to you about provincial court family practice. And there are 3 different types of provincial court registries in BC. The first is an early resolution registry. So there aren't many early resolution registries. The 2 early resolution registries are Victoria and Surrey. So it's important to know that before you can get started in either of these registries, unless it's an urgent application, one of the parties has to file something called a notice to resolve. And by doing that, you'll get information about having a needs assessment with a family justice counselor. My understanding is that that meeting with a family justice counselor can be virtual or in person. So it's a good idea to call and see what your options are. And then normally you have to complete a parenting course called Parenting After Separation. If you do identify as Indigenous, there is a Parenting After Separation course for Indigenous families. So it is important to mention that to the Family Justice Counselor, so that you can get a course that might be more tailored to your needs. And then bear in mind that the next step is participating in consensual dispute resolution. However, in a lot of cases, I see that that doesn't happen because there may be family violence. It may be that the relationship between the parties is not such that mediation is appropriate. So it's quite important, especially if you don't have a lawyer to speak up and say, you know, the situation with my ex, it's not very healthy right now. I wouldn't really feel safe to have a mediation with him. However, if things are amicable, it can be a really good way to keep legal costs down, as the Family Justice Council can help you prepare an agreement which can be filed in court and can potentially resolve some of the issues without having to go much further in the court process. So it's important to comply with early resolution requirements because ultimately that's what you need to get your case going. But in certain situations, and it's something that I've seen myself, you can apply to be exempted from the early resolution requirements or to have them deferred. So as is set out here, there's certain situations when early resolution requirements aren't appropriate. You'll get all of these slides after this presentation, so I won't go through all of them, but typically they're all set out in the bullet points, but it's when your matter is urgent. There are some ways to bypass the early resolution requirements, such as when you're applying for a protection order and if there's a priority parenting matter, and then the other bullet points set out. So the other type of registry is a family justice registry. There aren't many family justice registries. We've got Kelowna, Nanaimo, and Robson Square in Vancouver. And ultimately, to fulfill the steps for a family justice registry, what you need to do is attend a needs assessment with a family justice counselor and complete a parenting course, which is normally parenting after separation. I don't typically see people having to being required to participate in consensual dispute resolution in a family justice registry, because that would sort of take you to the early justice registry sort of courthouses. So typically the 2 steps in a family justice registry are attending the needs assessment and completing a parenting education course, such as parenting after separation. And then you can go ahead and file your initiating document, which is normally the application about a family law matter. So in certain situations, similarly to the early resolution registries, it's not always appropriate to go through the steps of a family justice registry. Again, it would be in situations of urgency. So if you refer to all of the bullet points set out as to when a family law matter is urgent, in most situations, you can file your applications and get straight to court. But just bear in mind, even though you can bypass the steps for a family justice registry, typically, if you do want to go back and apply for orders for family law matters such as guardianship, parenting time after you've dealt with your protection order or these other applications which are deemed urgent, you will have to go back and complete the steps for a family justice registry. So the most common registry is a parenting education registry, which is what you see a lot of because, as you've probably seen, there aren't that many registries that are family justice registries or early resolution registries. A lot will depend on where you live because you have to file typically where in specific geographic areas. For example, if you live in Delta, the expectation is that you file in Richmond Provincial Court. If you live in Burnaby, the expectation is that you file in New Westminster Provincial Court. So that's something to bear in mind before you file. Think about which location, geographic location you should be filing in. But typically, the parenting education registry is the most simple one, as the only step you need to comply with is to complete parenting after separation, or if you identify as Indigenous, complete the Parenting After Separation for Indigenous Families course. Bear in mind, it's quite a long course. It is online. It's several hours long. So I tend to advise people, I tend to give them a heads up and say, try and do it early because if you're working, you're busy with childcare, you have this 4-hour course. It's not often people get that 4-hour window to sit down and do it. And just bear in mind, if you are not fluent in English, it is quite easy to apply for an exemption of completing parenting after separation, as the court understands. Also, as you can see from this slide, the other bullet points, if you don't have access to the internet or have trouble reading or have a serious health problem. The courts are quite flexible. You just have to make them aware of the details. But typically what I see waivers for parenting after separation being done or typically when someone is not fluent in English, is they just aren't able to follow the course, and the court has been very understanding of that in my experience. So a family justice counselor is, they're not lawyers, they can't give you legal advice, but they are individuals who can help you with mediation. They know a lot about family law. They're able to draft parenting agreements. They're also able to draft agreements that include child support. They are knowledgeable about the child support tables and set of child support, and they can provide you with information and education about the next steps in the court process. So I think they're a really excellent resource and they're free as well. And they also write Section 211 reports at no charge. This isn't something you would necessarily be doing at the start of your case, but I think they're a very good resource and we're lucky to have them. So parenting after separation, I've spoken about that a bit already, but it's an online course to help parties understand the impact separation can have on their children, and basically just to try and encourage people to co-parent in a way that is in the best interest of their children, or, you know, if there aren't children involved, then basically just to um, sort of get along with each other. But bear in mind, if there are no children involved, for example, if you're only dealing with spousal support, then you would not have to do the course. Or if all the children are aged over 19, or you're able to resolve all of your issues in a consent order, then in those situations, you wouldn't have to do the course. So you're really looking more at people who have children who are under the age of 19 and may have ongoing parenting arrangements that they need assistance with. And one more thing to bear in mind is you might have to do parenting after separation twice or 3 times over the course of your case, depending on how long the litigation goes on, as it's only valid for 2 years. So, for example, if you did it in 2024 and then you resolve your case in 2025, but then in 2029 an issue comes up, it's possible that you'll have to do parenting after separation again, depending on the facts of your case. So how to get in front of a judge? there are lots of different ways. So what we'll do is I'll try and give you a little bit of a walkthrough of the different options of how to get in front of a judge. And this is a very helpful spreadsheet here. It might be a little bit overwhelming looking at it the first time, but ultimately, if you look at that flow chart, it just sets out all of the different ways you can get to court and the different applications. And it varies depending on urgency. The application about a family law matter is a standard application, but in cases of urgency, you've got the application about a protection order, the application about a priority parenting matter, an order to prohibit relocation, an application about enforcement, and then I would say less urgent would be an application for case management order with or without notice. And then if you're able to resolve all your matters by consent, which is awesome, then you would do the application for a family law consent order, which can result in you getting orders without actually appearing before a judge and just getting an order via desk order. So I've talked about the main applications. The one that is very common is the application about a family law matter. And that covers everything really. So in terms of parenting arrangements, we're talking about child support, spousal support, Section 7 expenses, guardianship, parenting time, parental responsibilities, also, companion animals, who's going to have it, and so on. So focusing on the application about a family law matter, yes, you can see these bullet points here. So those are the points that are covered, but bear in mind that it's very individualized. So you only have to apply for what you need assistance with, right? So if it's only parenting time and parental responsibilities and guardianship, that's all you would put in. But I would imagine if there are children involved, you probably need to do child support as well. Spousal support, that depends on the situation, excuse me, and companion animals. That also would depend on whether you have one and if you want to come to an agreement or, maybe there's some dispute about who keeps the family pet. So the way it works is if someone files an application about a family law matter, normally they have to hire someone. Well, they don't have to hire someone. It can be someone they know who's over the age of 19, who is not them. So the person who files the application about a family law matter cannot serve it on the person they want to serve it on. It has to be someone else over the age of 19. And then it has to be personally served on the opposing party or that person's ex. And then they have 30 days to respond with their reply to an application about a family law matter. This is one thing that people get a little bit caught up on. And I find it is a bit confusing as well for myself as a lawyer. And it took some getting used to. It's that if your ex in their application about a family law matter applies for example, parenting arrangements, including guardianship, parenting time, parental responsibilities, and child support, and you disagree with what they're applying for, but those are the only issues that are contested between you, then you don't do a counter application. You just do a reply and you set out your position. I disagree with what they've suggested, the parenting arrangements for X, Y, Z reasons. I disagree with the child support because they're not being honest about their income, or I actually am not making what they claim that I am making. Please also note that if they have asked for child support in their application about a family law matter, you will have to do a financial statement when you do your reply, attaching your tax documents for the last 3 years. And it's only if you want to apply for something that's not in the application about a family law matter that you do a counter application. So for example, say if you want to apply for spousal support and that's not included in the application, then you would do a counter application for spousal support and a reply for the other issues. So doing a reply to a counter application, so that's the next step. That's not always necessary because in a lot of cases, you may just have an application about a family law matter and then a reply to an application about a family law matter. So if there is no counter application, that is the end of a court documents, at least for the application about a family law matter. If there is a counter application, then it makes sense to do a reply to the counter application if you disagree, for example. Say if this person has applied for spousal support in the counter application, you can reply and say, I don't agree with their application for spousal support. I don't think it's appropriate. This is how much I make. There's no money left for me to pay my ex-spousal support, something to that effect. So another important application is the application about a priority parenting matter. This is one of the applications, but even if your case has already started and you've already got an application about a family law matter filed and you're waiting for the court process, you can file an application about a priority parenting matter for urgent issues. But what people need to bear in mind is you have to be really careful when you file these applications because they've intentionally made it very specified in terms of what you can actually file these applications for. So it can be if someone is refusing to return a child, but don't interpret that too literally, right? So for example, if maybe your ex is an hour late with returning the child, but they return the child that day, it's not a situation that I would say is an application about a priority parenting matter, because by the time you're in court, the situation would have resolved itself. Applying for passports and travel with a child, that's a common one. And it's important to get the application in as soon as you can. For example, we're in October now. If you have plans for December to travel, don't wait until a week before you want to travel to make this application, as you want to have, I would say, at least a month to get a decision from a court. And then, if you're booking international travel, especially around Christmas, it's expensive. So you want to do it as early as you can. So ultimately, if you're applying for a passport for a child or for travel with a child, then that's when you do the application about a priority parenting matter. Wrongful removal or wrongful retention of a child. There, we're typically looking at a child being removed from a jurisdiction. Assuming, where we're based, I'm kind of assuming that most people are based in British Columbia. But say if you have a parent or a grandparent or someone who's taken the child outside of British Columbia without your consent, that's a sort of situation where you'd say, hey, my child has been wrongfully removed from BC. I'm seeking an order for them to be returned immediately. And also applying to change a child's residence. So that would depend on the situation. As, for example, if the residence, let's say everyone lives in Burnaby and you want to move the child to a different residence, I would say that's not really a situation where you would be needing to fill out an application about a priority parenting matter. I would say it's more a situation where you're looking at something called a relocation, where one parent wants to change the child's residence in a way that would drastically affect the parenting time of the other parent. So, for example, if one parent lives in Vancouver and one parent wants to move to Nanaimo, that would, I would imagine, affect the parenting time if it's relatively equal. So those are the sorts of situations where you would do an application about a priority parenting matter. An application about a protection order. So this is one of the more urgent applications where an applicant is experiencing family violence, which is very broadly defined in the Family Law Act. People often think of physical violence, but it goes further than that. It's also emotional abuse, stalking, harassment. So it is quite broad, and this is a form you use when you're experiencing family violence. It doesn't have to be limited to you. It could also be family members who live with you. So it could be a child, it could be a parent, it could be a grandparent as well. And there are different ways to bring this application. You can do it with notice. If you do it with notice, then it just means that you would serve the other party with a filed copy of the application, letting them know when the hearing is going to be. And normally, excuse me, it will be, I'd say, at least a week and a half from the date that you file. Alternatively, if you do it without notice, that's when you try and apply for the order without giving notice to the other party. And in certain situations, that's, if you get legal advice, that could be what is recommended to you, depending on the urgency and the nature of the situation. You can also file an application for case management order to shorten the timelines. Is typically you need to give someone 7 days notice of the application, but if it's quite urgent, you could say to the court, hey, I'd like to serve the other party, but I want to give them 4 days notice, and it'll be up to the judge to decide. Okay, then there's also the application for an order prohibiting the relocation of a child. So yes, this is what you typically do if you're given notice by, your former partner that they want to relocate the child. It could be, I don't know, for example, to a different province or a different country. So you fill out this form just to say that you're opposed to the relocation of your child, and then that gets the court process going. And what I mean by that is It sets up a process for you to have a hearing on the merits. And what I mean by that is a situation where you can go to court, as can your ex, and give evidence about why you're opposed to the relocation. And the applicant or the person who wants to relocate can say why they're seeking the relocation, and ultimately it'll be for the court to decide. But by filing this form to prohibit the relocation of a child, you've notified to the court and the other party that you're opposed to this relocation and that you do not approve of it going ahead without it being addressed in courts. And then we've got the application for a family law consent order. So this is a situation where if the parents can agree on the orders, you can basically resolve your case with this application without going to court. So depending on what it is that you seek from these bullet points, if it's just parenting time and parental responsibilities and guardianship, you can just set out what you're seeking in terms of the schedule, how you want parental responsibilities to be allocated, if you want guardianship, for example, to be joint, and you just set that out on the form. If you want child support and Section 7 expenses, there will need to be some information provided to show the courts, what each parent is earning, because of course, if you have a situation where it's an equal or shared parenting arrangement, then there would be offset child support, meaning that the person who earns more will pay the difference in child support. So for example, say one person earns 50,000 and the other earns 30,000, you would take what the person who earned 50,000 is required to pay for child support, and the person who earns 30,000 is required to pay child support, and take that number away from the other one to work out the set of child support. If one party has primary residence, then the other parent's income would be relevant to determine how much child support they should be paying. And then you also have Section 7 expenses. So in that situation, even if you have a situation where one party has primary residence, both parties' incomes are relevant. So you have to set out the income of both parents so that the court can look at the application and think, well, does this make sense? What they're proposing for child support, does this actually match the federal child support guidelines? And for Section 7 expenses, are they doing it proportionate to their incomes? And for spousal support as well, yes, it would be important to have the income of both parties. And then also for companionship animals, if you've come to an agreement, for example, about who's going to keep the family dog or family cat, or what the sort of schedule is going to be, if it's going to be shared between each house, you can set that all out in the application, and a court can basically review it and make a determination on your application for a family law consent order. So an application for a case management order, these can be quite useful because I see them as like a catch-all form, because there's some things that don't really fit neatly into the other forms. So for example, all of the examples are set out on this page, but yeah, if you want to transfer a court file to another registry, which can happen as sometimes cases go on for several years, maybe you move to a different town, you want to be filing documents in a court registry that is closer to ideally where the children live and the parents live. So that's the form you would use. For management of a court record, file, or document, that's more general, but that's why it's a good catch-all form, because situations can come up when you need a situation like this. Or correcting or amending a filed court document. So for example, if you filed a court order, if you're self-represented, then a registry would draft a court order for you. But as lawyers, sometimes there could be an error in a court order. So you can file an application to say, this is an error that was made in the court order. This is a court summary sheet. We'd like an order giving us leave to file the order in the correct fashion so it reflects what was actually ordered. In terms of amending or correcting a filed court document. So for example, you might file an application about a family law matter. And let's say before you serve on the opposing party, you realize, okay, I've applied for child support and parenting arrangements, but I also want spousal support. So you can amend the application about a family law matter. Now, typically, you don't have to file an application for case management order to do this if you've just filed the application about a family law matter. But depending on where you've got to in your case, if a family management conference has already happened, and if the other party doesn't agree, then you would have to file an application for case management order to seek leave from the court for permission to amend your application about a family law matter. So yeah, you can also use these forms to ask for timeframes for the filing of a document or exchanging of information or evidence. Typically, that would be if you have a trial coming up, you might say, hey, I want to get the other party's documents 3 weeks before the trial. Sometimes you can do it more informally, but it can be good to have a court order in place so that there's something procedural that the judge can look at as well, which can ideally be enforced. And what is very common for these forms actually is asking for information to be disclosed by a third party person. So a good example of this would be if there's been MCFD involvement in a family situation, you can apply for MCFD disclosure. If there's been involvement of the police, you can apply for RCMP disclosure. And this is one application that is quite common with this form. And then you've also got these other sections like paternity tests, recognizing orders from a different province or country, and adjourning or rescheduling court appearances. There's another form that can be used to adjourn court appearances, which is called a consent adjournment form, but that's not applicable for trials. So it just depends on the situation. So the application for, if I could just get you to go back to the previous slide for 1 second, please. Okay. Yeah, that's good. Thank you. And if you could go, yep. So then, yes, we have another application which is similar to the application for case management order with notice, but this one is without notice. These forms can be really good because you can basically get court orders without a court hearing. So the sorts of things that you typically would ask for would be asking to be allowed to attend a hearing by a different method. So for example, if there's an in-person hearing and maybe you can't make it in person because of work or childcare obligations or because you live in a really different city, then you can ask for leave from a court to attend via MS Teams video or MS Teams audio. So you'd attend, via video like I am now or via telephone. You can also apply to waive or modify requirements for service. So for example, if you have an application about a protection order and you want to do it with notice, but you don't want to give a full 7 days notice, you could say, for example, I'm seeking, to be able to serve the opposing party with 5 days notice because my understanding is that they're going to leave the province in the next couple of days or in the next week, for example. I mean, it would just depend on your situation and the facts. And then recognizing orders from a different province or country. That is something that I don't typically use the application for case management order without notice to do, but one thing that I would use it for quite commonly would be for permission to serve an opposing party in a different way. For example, if you've made several attempts to serve them personally, and you're not able to successfully serve them, whether you've used a professional process server or you've had a friend who's over the age of 19 help you, then normally what I would do is I would file an affidavit setting out those attempts. And then I'd also say, this is my understanding of their contact information. I'm seeking leave to serve them, whether it be typically via email. And then, yeah, you send the application into the court. And if the court approves it, then you can, get your order and kind of continue with your application and serving the opposing party in a different manner via email instead of personal service, for example, which is required for an application about a family law matter. So moving on to the written response to application, the Form 19. This form is not mandatory, but it can be good to do. So for example, if you're served with an application about a protection order or an application about enforcement, or application for case management with notice, or an application about a priority parenting matter, and you don't agree, then you can just do a written response and say, I don't agree with the orders sought, and set out the orders that you would like to be made and set out your reasons for why. And in terms of the written response to application, there's not really a strict deadline on when you have to file the response. It just needs to be before the court date. But bear in mind, courts, they're open from 9 till 4:30, but the registries are normally from 9 till 4 p.m. So, for example, if you had a court hearing on Friday and you've got a written response to application, you want to be sending it in for filing. If you're email filing it, at least a couple of business days before. If you're able to actually physically go into the registry, then you could probably just do it the day before court. But ideally, you want to have a chance to serve that on the opposing party or their lawyer. So it's good to just plan a little bit ahead. But courts do understand, for example, if you're served on the 14th of October, well, that was Thanksgiving. If you were served like today on the 15th of October, and say court was next week, and then you weren't able to file the written response until the day before court and then serve the opposing party. Judges generally understand, especially if you don't have a representation, but it does take a little bit of time, but they can be good to do, just to give your position on the application, but they're not mandatory. So, you've filed your application. What do you do now? So it really depends on the application. Some require personal service. The main ones that require personal service are the application about a protection order and the application about a family law matter. So I've talked about this a little bit, but yeah, it's important that you have any person over the age of 19 who is not a party. So typically it would be the person who filed the document who shouldn't do it. So you can ask a friend, or you can hire a process server. I understand that's not always affordable for people because a process server can cost about $200 roughly. But the benefit of using a process server is they know how to do it all. They know how to serve a person properly. They'll do the certificate of service proving that they've served a person, and then you can just file that in courts. But you also can get the certificate of service from online or from a registry and have whoever helps you complete the service fill that out as well and file that in courts. Okay. So now a lot of this depends on the application. So if you're served with an application about a family law matter, you will have 30 days to respond, typically doing your response to an application about a family law matter, and possibly a counter application if you have something additional you want to apply for, like the example I mentioned before, you're served with an application just for parenting arrangements and child support, and you want spousal support as well. And remember, if there's a financial issue, you also have to do a financial statement. For the other applications, it really depends because for an application about enforcement or an application about a priority parenting matter or an application for case management order with notice, typically you're given at least 7 days notice of the application. So bear in mind, it could be a situation where your ex is given or whoever's serving you is given the application maybe 14 days before the court date, but they might not serve you until 7 days before. So depending on what the application says, you could do a written response to application in Form 19. But in some situations, if you know you're going to attend the court hearing, it's not mandatory to do the written response to application. It just depends on how you want to go about running your case. If you know that you'll be able to show up in court and give your position, then it's not a situation where you have to do the written response. It just depends on the person. But the application about a family law matter, you do need to do a response to protect yourself procedurally so that whoever started the application isn't able to proceed without notice to you. And yeah, after the 30-day period is over, after being served with the application about a family law matter, whoever served the application about a family law matter has the right to ask for the court to schedule a family management conference. And depending on whether or not you've responded to that application about a family law matter, you will or will not be given notice of the family management conference date. So it's really important to respond to the application about a family law matter. So the family management conference, it's been in place for about 2 years, and it's sort of like a mini hearing, mini mediation, but you have a situation where the judge is trying to help you resolve all of the issues without there being further court involvement if it's applicable in the situation. So normally, the people who attend are the parties. They're all remote, the family management conferences. So they always happen via MS Teams video or MS Teams audio. The preference of the judges is that they happen via MS Teams video, because in that situation, the judge can actually see all of the parties and connect with them in that way. Please note in provincial court, if you don't speak English fluently, then you can ask for an interpreter for free. So it's important that you just make that request early to the registry. Hi, I need an interpreter for, I don't know, Spanish or whatever language it is you're fluent in. And then you would have the interpreter attend the Family Management Conference or FMC as well to assist you with any interpretation you need. And it can be every single word can be translated if you need it, or if your fluency in English is quite good, then you can just say, excuse me, I only need interpretation assistance for certain words. But yes, so typically you'll have the parties and the judge attending, possibly an interpreter if it's required for either or both of the parties, and then lawyers if you have legal representation. If you don't have lawyers, it is possible to bring a support person or advocate, but I would say let the other party or their lawyer know ahead of time, because it's going to depend on the comfort of both parties. If you have a support person who is perhaps maybe like your parent, and the other party doesn't particularly like your parent or feel comfortable with your parent, they can validly say to the judge, look, I don't feel comfortable with this individual being there. I prefer that they not attend. And the judge would probably lean to the other person's comment and say, you know what, we're not going to have the parent of the party here. So just bear that in mind. And orders that can be made at an FMC, basically anything that's in your application about a family law matter can be made at an FMC. So you can have orders made typically for parental responsibilities, parenting time. If someone's not a guardian, then for contact, child support, spousal support, and guardianship. Typically at an FMC, the orders that are made are interim, but if there's general agreement between the parties, then the court can make final orders. So in terms of other steps, so as I'd mentioned, if one of the issues in your application about a family law matter is child support, you are supposed to do a financial statement within the 30 days of being served, if you're the person responding to the application. If for whatever reason you don't, it's very common for judges to make orders for financial disclosure. They'll sort of say, hey, you haven't done your taxes. How long do you think you need? Will 30 days be enough? And they'll make procedural orders, even if you don't agree, for a financial statement to be done, perhaps within 30 days of the date of the family management conference. Other orders they can make are for further steps in the proceeding. For example, if you for example, don't agree about the parenting arrangements that the other party would like, they might say, okay, this is likely going to trial. Let's order a Section 211 report to be done, which is when a family justice counselor at no cost can interview the children, interview the parents, observe them in both homes, and make recommendations about parenting arrangements, write a report, and that will be filed in the court and can be relied on at trial. So that's sort of what could be done for dispute resolution. And in terms of other orders that can be made, they can make conduct orders. They're very sort of standard conduct orders in family law. So for example, if you have a situation where maybe well, there doesn't need to be a situation. Just typically it'll be things like, don't talk to the children about court, don't talk to them about the family court litigation, don't involve them in adult discussions, and yeah, basically put the children first if it's a situation where there are parenting arrangements involved. So those orders are typically made quite easily by a judge, as they're ultimately trying to lessen the conflict and help the parents to move forward in a way that is, you know, in their best interest and in the best interest of the children. Bear in mind that family management conferences are not very long. They are 45 minutes long typically. So by the time the parties have introduced themselves and each parent has, you know, sort of explained why they're there and what they're seeking, that might be about 20 minutes. So if there's a lot of disagreement between the parties, it may be that it needs to go to a trial. If there is quite a lot of resolution and you're just trying to fine tune something like a parenting time schedule, then the judge will work to try and get a parenting time schedule into an order. But for example, it may mean that there's not time to deal with child support at the FMC. So they might then recommend that there be a follow-up family management conference to deal with child support and maybe Section 7 expenses. And if the parties are too far apart, say each parent wants primary residence of the children and they can't agree on it, it may be that the next step would be then to be adjourned to the judicial case manager to set dates for a trial. So it's good to go into a family management conference with an idea of what you want to do if it doesn't resolve. And I don't mean going in negatively. I just mean if it does go to trial, how many witnesses do you think you will need? How many days do you think it will take? Because typically at the FMC, that's where you get the order that says, okay, they've been adjourned to the judicial case manager for a 5-day trial. One parent thinks they'll have 2 witnesses, another parent thinks they'll have 3. So it's good to go in just thinking, okay, great, let's see if we can resolve this. If we can't and we go to trial, these are the witnesses I think I will need. And always remember to count yourself as a witness as well, because you're a party and you're one of the most important witnesses. And some other steps that can be scheduled are a family settlement conference. So these used to be called family case conferences a couple of years ago. They are similar to family management conferences, but they're a little bit different because at a family management conference, a judge can make orders that neither party agrees to. For example, let's say both parties want to have shared parental responsibilities, excuse me, but one party wants to have final say. And the other party also wants to have final say. The judge can just say at an FMC, okay, I'm giving party 1 final say on parental responsibilities in an interim order. And then perhaps this can be adjourned to a trial if this is really a contentious point between the 2 of you. At a family settlement conference, it's a little bit different in that the judge is trying to see what issues the parties agree on and the ones they disagree on. You don't get a family settlement conference automatically. So if you attend an FMC and things are quite amicable with the other party, you can ask the judge, can we be adjourned to a family settlement conference? And there, basically what typically is happening is the judge is trying to make orders that are by consent. So they typically only make orders that are by consent at a family settlement conference unless they're procedural. So for example, if one of the issues is spousal support, or child support and the parties haven't filed financial statements, it would be quite normal for a judge to make an order for a financial statement to be prepared by each party and filed by a certain date, as without that, it's very difficult for a judge to make sense of these issues. So that's sort of how a family settlement conference works. And typically it's similar to an FMC. It would just be you as a party, the other party, the judge and lawyers if you have lawyers, and possibly you could bring a support person. However, the other party would need to agree to it, and they still typically happen remotely via MS Teams video or MS Teams audio. But again, the preference is MS Teams video. So,
Oh, sorry, I'm sorry to interrupt you. Just because we're between topics right now, I figured it might be a good time. Did you want to take a quick, like 5-10 minute break?
I think, yeah, maybe if we took like a 5-minute break, I would be good with that.
Perfect. Yeah. So why don't we call it 6:26 because it's
6:26.
Okay,
Sounds good.
perfect. So we're just gonna
Okay,
do a quick 5-minute break, everybody. We'll be right back. Thank you.
perfect. Thank you.
I'm gonna pause the recording for right now.
Okay, so welcome back, everyone. So now we'll just talk a little bit about trial preparation conferences, which are also referred to as pre-trial conferences. So typically, what I do is as soon as we get given a court order that gives us leave to schedule a trial, I also ask for the order to include a pre-trial conference at least 30 days before the trial, sometimes 60 days. And those can be really good because it's a good way to see what the other party's case is. You'll have a general idea from their application about a family law matter or their reply. However, at this point, at the trial preparation conference, normally the parties will come prepared with the witnesses who they intend to call at trial. So that will give you an idea of what, they'll be saying at trial and also what kind of evidence they'll be relying on. For example, is there a Section 211 report? Is it going to be ready in time for trial? If it's not ready in time for trial, is the trial going to be able to proceed as scheduled, or do you need to adjourn the trial? And then also, what sorts of documents you'll be relying on at trial. It's a good opportunity to talk about these issues and see if you're on course to actually finish the trial in the scheduled days. So, for example, if you have a 4-day trial and each party wants to bring 8 witnesses, you're unlikely to finish in time. So those are the sorts of things that a judge will pick up on, or if you have legal representation, your lawyer will pick up on those issues. And normally, you're meant to file and serve a trial readiness statement at least 7 days before the trial preparation conference. Self-represented litigants don't always do this, but it can be a good way actually just to prepare for the trial because you'll set out who your witnesses are, what orders you want at the trial preparation conference. For example, it could just be an order that the parties will disclose the documents they intend to rely on by a specific date, maybe 3 weeks before the trial, 30 days before the trial. That just gives you an opportunity to see the other party's documents and for them to see yours and to prepare. And also, you set out the issues that need to be dealt with at trial because, for example, you may have dealt with certain issues and resolved them through interim orders. So it could be that the only remaining issues are, for example, spousal support and how to figure out the schedule for a companion animal. Or it could be everything: parental responsibilities, parenting time, guardianship, child support, Section 7 expenses, spousal support, dealing with a companion animal. And then you also set out if there are any existing orders that cover some of the issues that need to be dealt with at trial, such as an interim order or a written agreement. And it's a good opportunity to see if financial statements are outdated, given that litigation can take a while, could take a year. Typically, for trial, it's a good practice to have a financial statement that was filed within at least the last 6 months. Though it does depend, you have to think of where you are and where we are in terms of the tax year. As you know, tax returns generally aren't available until sort of April, May. So if there hasn't really been a change in your financial circumstances, you may not need to do a new financial statement. But it is quite important if you're dealing with support issues like child support or spousal support or Section 7 expenses that financial information is updated. So we've already talked about having potential witnesses, and a good thing to sort of canvas your mind to is technology needs. So if you have witnesses who live in a different country or they live in a different province who you don't think are able to come and attend your trial in person, you need to ask for permission from a judge to let someone testify from a different location. And then the judge might have questions such as, okay, well, does this person have access to a computer? Do they have access to a stable internet connection? Are they going to be able to, have maybe 2 hours available to testify during your trial? Also, interpreters are really important, especially if the language is maybe not as common. You want to ask early so that the registry can book an interpreter for your trial to make sure that you're understanding everything clearly. And also just bear in mind if both parties don't have lawyers and there is an issue such as family violence, you can talk to the judge about ways to deal with that, for example. So someone might not feel comfortable being cross-examined by an ex if there's been, some sort of violence towards them. So you can see if there are any accommodations, such as maybe testifying in another room in the court, or doing part of the evidence via video, or instead of the person who has maybe subjected someone to family violence, cross-examining this person, having the assistance of maybe a duty counsel lawyer. So they're just different things to turn your mind to. And then any other sorts of accommodations needed by a party, whether for a medical reason or so on. And ultimately, trial readiness statements can be a good way so that you can just get a flavor of what the other party will be asking for at trial, and they can get the same from you. And then also you can, because they have to be filed a week before the trial preparation conference, you can reach out to the other party, or if the lawyers are involved, then the lawyers can say, oh, you want to exchange documents 3 weeks before trial. We'd like to do it a little bit closer to trial, maybe 2 weeks, and you can just have that conversation before the trial readiness conference so that you can be on the same page when you appear before the judge, depending on the circumstances. So a provincial court trial. I'll just give you a brief overview of this, as it looks like you'll be talking about this in more detail during week 7 of your course. But generally, what happens at trial is the person who started the court process, who filed the application that's scheduled for trial, goes first, the applicant, and they'll give an opening statement setting out, what they're seeking at trial. Generally the orders, right? I'm looking for equal parenting time, set off child support, equal parental responsibilities, and a conduct order, for example. And I'm just giving an example. It'll depend on, each case and what you're seeking. And they can give an opening statement setting out, what they'll be relying on at trial. So, for example, they could say, I will be testifying as a witness, and I'm also calling 2 other witnesses. They are, insert names of these people and the relationship to them, my mother and, my former employer, my cousin, whoever it is, and the orders that they want to seek. And I've seen it done different ways. So sometimes then the respondent, the person who's responding to the application, also gives an opening statement, sets out, the orders that they want and what they're hoping the court will order and the witnesses they'll be calling. But sometimes the court might just have the applicant give their opening statement, call their witnesses, lead all of their evidence, conclude their case, and then have the respondent give their opening statements, set out, the orders that they're seeking, who they'll be calling as witnesses, and then let the respondent give all of their evidence, call their witnesses, present their documents, and so on. And, after that, once the evidence has been led, then typically you have submissions. So as I sort of was explaining before, the applicant normally will start with their evidence, which is called their direct testimony or direct examination. If they have a lawyer, then a lawyer will ask some questions to get the answers that they kind of, need them to say out of them. If this person doesn't have a lawyer, then you just kind of speak about the different issues. It's good to break it up into topics. So speak about parenting time, then speak about parental responsibilities. If guardianship is an issue, speak about that, and then move on to sort of financial issues, just so it's clearer for the judge. Now, bear in mind that each witness is subject to cross-examination. So, for example, if you're the applicant and you give your evidence and you finish giving your evidence, it could take a half day, it could take a full day. Then the other party has the right to cross-examine you, which means they can ask you questions about your evidence to either sort of discount it or challenge it or to get further information. So if the other party doesn't have a lawyer, they would do that themselves. If they do have a lawyer, the lawyer would be the person to ask you the questions. And the same goes for all of the witnesses of the applicant. So for example, if you've also called your mum as a witness, maybe a friend as well, they would give their direct evidence, sort of talking about the issues they want to cover. And then the opposing party has the right to ask some questions called cross-examination based on the evidence and testimony that they have given. So in terms of this second bullet point about depending on what type of schedule is agreed to, supporting witnesses will testify either in between each party's testimony or after both parties testify. So typically what happens is you have the applicant's witnesses first, and then you just have to be sort of creative or think ahead about the order in which you're going to call your witnesses. So if you have two friends or two family members who are coming to testify in support of your case and they can only get one day off work, which happens to be the first day of trial, then what I would do is I would call those witnesses first, and then hope that with cross-examination they would be done that day. And then I would call the applicant as the second witness on the second day. So you just have to look at the availability of the parties and figure out what sort of witness schedule makes sense. But normally, so the evidence is cleaner, you have the applicant and all of their supporting witnesses testify first. And after they've given their testimony, they are subject to cross-examination. And then when all of the evidence has been led for the applicant, at that point, the respondent would then start their case. Respondent might testify first, or their supporting witnesses might testify first, depending on their availability, right? If they can only testify on a certain day, then you would expect that to be accommodated so that their evidence can be heard. And then once all of the evidence has been provided, and remember evidence, it's oral testimony, but it's also documents, it can be audio, it can be videos. Once all of that has been presented to the courts, you normally have closing statements and submissions where you just summarize what the evidence has sort of shown. You don't need to go into excessive detail because the judge has been there during the trial making notes, listening to everything that's been said, but you can just summarize some sort of highlight points of, maybe the applicant's evidence if they're the applicant and their supporting witnesses, or the respondent's evidence and the evidence of their supporting witnesses. And just again, emphasize why the orders that you are seeking should be made. And in some cases, typically, this is more if lawyers are involved. So if lawyers aren't involved, this isn't as likely to happen, but the judge might say, I would like you to do written submissions on each issue, summarizing why the order should be made. So it really depends on if there are lawyers involved or not. If there are no lawyers involved, then it's more likely to be, I would say, oral closing submissions and closing statements. And as I said, this doesn't necessarily have to be very lengthy, because if you've just had a lengthy trial, the judge has all of their notes anyway. You just want to sort of summarize why the order should be made by the judge. So after the trial has been made, the judge will give you reasons for judgment. Now, they can either be oral or written. And if they're written, then you'll get, a detailed decision setting out the evidence, what the judge made of it, their findings on the credibility of the witnesses and their testimony, and ultimately the decision that they're making on all of the issues from the trial. So that would be a written decision. However, it can also be an oral decision where you get scheduled to come back to court for the judge's decision. They'll give a decision orally, and they will ask the questions the parties, if they have any questions. For example, say there's a parenting time schedule, they're normally pretty good. They'll say when that parenting time schedule is starting, but there might be little details that, the parties need clarification on, like, oh, okay, well, if a child is sick, what's the expectation? Do we have to give makeup time? Or if the child needs to go to daycare, does this affect the schedule? So that's your opportunity to just ask any questions with the judge present to clarify, their order, if there are any sort of gaps in the order that you anticipate being an issue when you walk out of the courtroom. If there are no lawyers involved in provincial courts, the judge would just, well, even if there are lawyers involved, if a judge does a written decision, they do their written reasons for judgment. If lawyers are involved, though, based on those written reasons for judgment, normally the lawyer for the applicant, will prepare a formal order setting out what has been ordered in the reasons for judgment, as the reasons for judgment don't just include the decision, but also include the judge's findings on the evidence and the credibility of the parties. If lawyers aren't involved, then the provincial court would draft the final order and would normally send it to the parties with the contact information that they have available with the court. So it could be email, or it could be, like, if it's just a home address, then it could be mailed to them. And that's typically how it works with a final order from trial. And sometimes after trial, depending on what the parties have asked for at the outset, a judge could be asked by one of the parties to make an interim order instead of a final order, but typically after a trial, the judge will make a final order. So to sort of round up, I'll just sort of take you through some of the important family law statutes. So the Provincial Court Family Rules are a really good resource as they set out the steps to take for responding to applications. They tell you which forms to complete, and they also let you know what a judge can do during certain appearances and what forms to use. So I'd recommend, clicking on the link at some point when you get the slides and just going through the Provincial Court Family Rules. There's something that I check quite a lot as a lawyer just to refresh on certain topics and certain types of applications. And if you have some time to just go through them, they can be a really good resource to just set out. I'd say the most helpful one often is timelines. How long do I have to respond to this application? When do I need to serve this person? But also remember on the actual applications themselves, it often tells you what the timelines are for service on the opposing party as well. And then the other piece of legislation that's very important in family law is the Family Law Act, because it applies in provincial court and it applies to both married and common law spouses. And that is sort of what, if you are going to trial, you would be looking at when you're doing your preparation. Because, for example, if you're looking for parenting time orders, you would look at Section 37 of the Family Law Act, which sets out the best interest test for children. And it's good to just go through all of those sections of the Act, but, it goes by letter, Section 37A and so on, and just think, okay, like, how do these different factors apply to my situation? And how can I convince a judge that this is why it would be in the best interest of a child or children to have a parenting time schedule that I'm seeking? And in terms of the Family Law Act, it also sets out definitions, right? So in Section 1, it sets out the definition of spouses, it sets out the definition of family violence. It sets out the test for applying for a protection order if there's been family violence. And there are also provisions about enforcing court orders or agreements, and also just sort of keeping the court process going in a way that is productive and appropriate, and where there's not undue delay in a court process. So it's good to sort of go through the Family Law Act. It's quite a long provision, but it can be quite helpful if you look online. You can just sort of control F the topic that you're most interested in, whether it be relocation, family violence, an application about enforcement, and it can be a good guiding, good guiding force when you're dealing with a family law case. So another good resource is the Federal Child Support Guidelines. So basically, they set out how much child support someone should pay based on the province they live in, how many children there are, and how much money the person who has to pay the child support makes every year. And it could be a situation where you have two payors because you have a shared or equal parenting time arrangement. So in that case, you may need to be sort of looking on the table for two different incomes, right? So for both parents, if you would both pay, and they would be set off child support. But also, if you just go on Google and put in child support calculator, there's a government form where you can just select your province, select the number of children, put in the income of the payor, assuming it's just one person who's paying child support, or even if it's two, and it will just tell you the number. And I use that quite a lot just to get a quick number, as with the federal child support guidelines. They do have tables and they have incomes going up to 150,000, but sometimes it can just be easier to just type it into the calculator. Okay, the payor makes 80,000. We have 3 children. We live in British Columbia, and then you get the number for the child support. So that can be another way to deal with child support calculations. And then if you have a lawyer, they can help you with software, but a lot of lawyers have access to called DivorceMate to calculate how much child support is payable. And the benefit of something like a DivorceMate calculation is that it doesn't just show you child support, but it also shows you spousal support, and it also shows you the proportion that each parent should be paying for Section 7 expenses proportionate to their income. So as lawyers, we generally use DivorceMate because it's a little bit more comprehensive, but depending on your situation, if you do have access to a lawyer or not, the federal child support guidelines are a good starting point to figure out how much child support is payable by either parent or one. And then for spousal support, we rely on the spousal support advisory guidelines, and they look at, first of all, if someone's entitled to spousal support, because spousal support is not necessarily a given. It's so fact specific. It looks at what the relationship was like. And by that, I mean, what roles did the parents take on during the relationship? Was one parent a stay-at-home parent? Was there any agreement between them that if, they separate, but one person would pay spousal support? And so the spousal support advisory guidelines are a good starting point to figure out, if spousal support is appropriate. And it also will sort of set out how long it would be appropriate for spousal support to be paid. And then you also have tiers with spousal support. You have the low range, the mid range, and the high range. So what would be appropriate really depends on the situation. And as I mentioned, we do use the spousal support advisory guidelines, and the software that lawyers use through DivorceMate tends to include the spousal support advisory guidelines. So that's why we use it, as it's quite comprehensive, as it will include the federal child support guidelines in terms of the amount that is recommended for child support, and the spousal support advisory guidelines, which sets out what the appropriate entitlement is for spousal support, and it may be that there's no spousal support entitlement, or if there is, how long it should go on for, and what the appropriate amount is. And then it'll give you the option of the low range, the medium range, and the high range for spousal support. Excuse me. And thank you for listening to my presentation. That is pretty much everything. If you have any questions, I think Rachel or Jennifer will let you know kind of how to ask me some questions.
Yeah, so if everybody, if you have any questions, just please enter them into the chat. Again, just leave your mic and your video off just to maintain privacy. So any questions, just type them into the chat box. So there are a couple that have come in through already. They've come in kind of as we've been talking, so some of them range on some of the topics, but the first one is, and it might have already been touch base, but parenting after separation exemption, if it is required, is that by a form or some formal application?
So there is a form. If you go on Google, it's I believe it's just called Parenting After Separation Exemption, but let me just double check right now. So I give you, yep. So Parenting After Separation Exemption. Yes. So what you have to fill out is something called a notice of exemption. And then you need to send that. So it's on Form 20. And you just have to put your name, who's filling it out, and why you request to be exempt from a parenting after separation course. And then what you need to do is they include a link to the Family Justice Services Division. So if you click on that link, then you can find out which family justice counselor is closest to you and then submit it to them. So normally you might need to call them to get an email. I typically fax it. I know fax isn't that easy, so it's probably best to call them, see if you can get an email or drop a form in. But there is a form, Form 20, the Notice of Exemption from Parenting After Separation.
Thank you. Okay, this might have been touched already as well. I think it was Form 22, but they were just mentioning how an FMC is often the first appearance in court. So how do you seek an interpreter prior to that, instead of just like at the FMC? Yeah.
Sure. So what you would need to do is just either go in person to the registry or call them. And as soon as you get the date for the FMC, normally you get the date over a month in advance, sometimes 2 months in advance. Just call the registry and say, I require an interpreter in whatever language you need. Please can one be ordered? And then normally they will do it. If you have a lawyer, it's a little bit of a different process. You just have to have your lawyer write a letter to the registry, email it into them, and just say, we have an FMC on this date. This client requires an interpreter for whatever language. And then normally the registry do book the interpreter for the FMC.
Perfect. Um, how long does it take for the reasons for judgments to be issued usually?
It really, really varies because it's dependent on the judge's calendar and the schedule and how long the trial is. So if it's a 1 day, 2 day trial, then possibly you could get the reasons for judgment. If it's a 1 day trial, sometimes the judge might make the decision that day, especially if it's about something like a protection order, because they don't really want to leave the parties hanging. They want to make it clear whether or not a protection order is going to be granted. If you're dealing with a trial that covers all of the issues like parenting arrangements, child support, spousal support, I would say you're looking at least a month, possibly 3 months. But bear in mind, it really depends where you are and what the issues are. So say if one of the issues is where are the kids going to go to school in September and you have a trial in the summer, a judge will normally work hard to get a decision to you before school starts so that you have clarity on where your child's going to school. But it really does depend on the registry location, how long the trial is, and how busy the judge is to be able to get that written judgment done.
Okay. I know for a case that we have right now at my work, we're on month 4 waiting for the reasons for judgment, and it's just kind of normal. So yeah.
Yeah, can take a while, unfortunately.
Mhm. Another question is, why can a case be sealed? I'm not sure, that's a little broad, I guess, but
Yeah, I mean, I think it really depends on the facts. Case sealing is not really something I see a lot, to be honest, but it would just depend on the nature of the case. Because in family law cases, the parties and their lawyers, they have the right to search the files. So if there's really sensitive information, for example, before a directive came out a few years ago, what some people used to do was include photos that showed like private parts of their child to try and prove maybe that there had been some sort of abuse. But now that's not permitted anymore. But in a situation like that, perhaps if there are images of a minor's private parts, that could be sealed so that, no one has access to that. But in terms of sealing the whole case, the whole file, that's not something that I've really seen, but it would typically be for confidentiality reasons and to protect someone's privacy. But there's already a level of privacy in family law cases because typically the only people who have access to the documents are the parties, their lawyers, the registry, and the judge. So um, that's what I would say about sealing, but I think it's a little bit case specific depending on, why you'd want a case to be sealed.
another question here. Basically, why would someone file with a priority registry rather than a regular registry? Like kind of the main difference. And
Honestly, it depends where you live. So you don't really have that much choice. If the parties live in Vancouver and the child lives in Vancouver, you're expected to file in Vancouver, and that happens to be a family justice registry. If you live in Surrey, you're expected to file in Surrey, and they are an early resolution registry. So it's not really like you get to pick which registry. Geography decides it for you, and then you're stuck with whatever registry you have, whether it be a parenting education registry, an early resolution registry, or a family justice registry, at least in provincial court. That's kind of the limitation.
is there a form to apply for a conduct order?
Yes. If you want to apply for a conduct order, I would say it's best to do it in the application about a family law matter when you're already applying for parenting orders and so on. If you've kind of, that ship has sailed, you've already filed an application about a family law matter or a reply, you could do it a bit informally at the family management conference. It's best to give the other party a heads up and say, hey, I'd like to enter into this conduct order on the following terms. And then you can just say to the judge, oh, I'd also like to enter into a conduct order. And if you don't have access to it, I'd recommend getting access to the pick list, because then you can basically just tell the judge, these are the terms I'd like from a pick list as a conduct order. In shorthand, it'll give you a letter and a number like D26, D27, and then it's a lot easier for the judge to make that order. But yeah, I would say if you're doing it at the beginning of the case, do it an application about a family law matter. And then otherwise, if you have a court appearance coming up, like a family management conference or even a trial preparation conference, you can mention it to the judge. Hey, I'd like a conduct order. And if you can, let the other side know in advance, because if they agree to it, then the judge would probably do it quite easily.
Um, okay, so if one part or if the other party files financial hardship after being served for child support,
Mhm.
does that party then have to provide their financial information for hardship?
Yes, that is normally what would happen. So if someone's claimed undue hardship, then normally at the same time as claiming that, they would file a financial statement. However, if you don't have a lawyer, it's quite important to just do a bit of your own due diligence, right? Because um, depending on what the undue hardship claimed is, normally someone who's claimed undue hardship, they're meant to provide additional disclosure. It could be, for example, bank statements. It could be the incomes of all the people living in the home that they reside in. So yes, there should be additional financial disclosure if someone claims undue hardship, but depending on whether or not you have a lawyer, it might require additional court orders, because with financial documents, people don't necessarily just give them over if you ask for them. You might need to actually apply for specific orders. And you can do that in an application for case management order and ask for specific disclosure to be provided if the other party is not cooperating with your requests for financial disclosure.
Perfect. This one might be a little bit more about evidence, but they're asking if there's family violence items or witnesses can be brought into like a family matter without having it filed with like a police or a criminal matter.
Possibly. It really depends on what sort of evidence and family law violence items you're talking about. So, um, in provincial court, it's up to you sort of what evidence you want to bring in. So, for example, if someone has photos of bruises or injuries, or they have video recordings of, maybe verbal abuse, property damage, you can bring that evidence in without a police report, but it's just important that you be organized, because if you're going to a trial, you need to speak to the court registry early to say, I have a video I want to play. You can't just assume you can show up with your phone, right? You want to have it on a USB device, and you want to have duplicate copies of that USB so you can provide it to the opposing party, their lawyer, possibly the judge. And you want to talk to the registry about, okay, I have a USB device. Um, I'm going to need an HDMI cable and a small TV, so I can play that video evidence or that audio evidence. So it really depends on what. It's a little hard to know without knowing kind of exactly what, but we're speaking more generally. So no, you don't need to have a police report or police disclosure to be able to rely on documents of family violence, but you just have to be a bit organized about how you get that evidence in, whether it's, a written statement or a photograph or a video or audio evidence.
Okay. And then I think this was touched a little bit on, but for the deadlines for replying to each of the forms,
Mhm.
usually the form itself sets out the timeline for a response, or it's usually in the rules. Is that correct?
So normally the form itself will say how long you have to respond. And typically, good practice, if someone is served with an application about a family law matter, normally the registry will give you instructions about filing a reply. So I will always give the opposing party the application about a family law matter and instructions for filing a reply. But on the actual applications, normally it will say you have, for example, for an application about a family law matter, you have 30 days to respond to this application. So most applications will set it out, but when in doubt, if you're self-represented, I'd recommend calling the registry. They can't give you legal advice, but they can maybe set you up with an appointment with duty counsel. And also bear in mind that you can apply for extensions or you can apply for adjournment. So it's important to get some legal assistance to do that properly from duty counsel if need be.
Um, if somebody's changing from one province to another, do they need to start with like a family management conference, or I guess they'd have to do like bring an application?
It really depends on where you got to in the other province. If you already have orders, you could potentially apply to register those orders in the province you've moved to, but it depends kind of what the orders are about and what they say. Um, if you want to get brand new orders in the province you've moved to, then you'd probably want to do an application about a family law matter, but you should, when it says if there are any existing orders, you should attach the orders from a previous province if they overlap with what you're applying for in your application about a family law matter, because there could be jurisdictional issues and the judge will want to be able to sort of understand what has come before in the other province to figure out what should be done in the province that you've moved to.
If a party is not able to be served, the form that's used, the application, I believe, right? I
Normally
believe you
the
talked about it. So if they're not
yes.
able to be served, what form could they use to get a different message?
It's normally the application for case management order without notice or attendance, and you just have to specify. So on the form, it gives you like different things you can ask for. So you would just tick serving someone in a different manner, and then you'd specify how you want to serve them. So it would be, for example, via email or leaving the documents posted to their door or giving them to someone you know they're regularly in contact with, like their mother. But you would have to also provide evidence as to why you can't serve them in the usual way. For example, via personal service. So if you have someone who's attempted to serve them multiple times, then you can have them do an affidavit setting out their service attempts. But it would be the application for case management order without notice or attendance, which you would use in that situation.
Okay. Um, so there's a couple questions just to the question people, or the people asking the questions. There is some questions about trial, but we do have a specific um session specifically on trial. So we're gonna go over some of those questions during that week instead.
Okay, sounds good.
Yeah.
I think if there's any other questions about affidavit or evidence, that's also going to be touched on later on. Same with financial statements. A lot of that will be going over in more detail in the coming weeks. So if possible, we should hold off on some of those questions until those
mhm.
presentations happen.
We also have our next session next Tuesday about applying for specific orders. So some of the questions, again, I know the other hosts can't see the questions, but just explaining that some of these will be talked about in more detail. So the questions should be answered at that time.
Perfect.
I don't know why it's not showing up on my end. I don't know if it's because I'm sharing my screen.
It should just be for hosts and co-hosts.
Hmm.
There's a question about being served at their place of work. It's the where they can be found, essentially, as long as the actual person is there in person. So the person can be served at their home, their work, the golf course,
Hmm.
their favorite restaurant, anything like that.
Yes, any place that you
Mm-hmm.
can just basically get the documents to them
Mm-hmm.
is appropriate for service.
And again, some of the evidence that's going to be gone through as well in some of our other sessions. Um, Statements from. Can a party object to having statements from other parties, and they won't be allowed as evidence? So I
It
guess if there's documents, I guess that the other party objects to.
You can object, but it depends on the statement because when you say statement, are you referring to an affidavit? Because another party can get affidavits done by other individuals. If it's just a general statement, bear in mind it's provincial courts. If the parties are self-represented, you can say, I don't think this document's appropriate. I don't think it should be used as evidence, but it'll be up to the judge. And typically in provincial court, judges allow quite a lot in, but it just goes to weight, right? If you're just talking about a statement that's like undated, unsigned, but you can't really prove was written by this other person, the judge would likely give it limited weight, but they won't necessarily accept your objection to not use it at all in the case. But you're welcome to sort of try and let the court know, let the judge know what your objections are to the document being used.
So there's a question about penalties and sanctions, which I don't believe is dealt with in provincial court. Is that correct?
It depends. I mean, you can apply for a fine because you have the
Mm.
Family Law Act, right? So you can apply for fines of up to $5,000, but
If it's
generally,
like usually withholding disclosure,
yes.
creating delays,
Exactly.
financial
Not
hardship.
complying with court orders, not complying with orders for financial disclosure. But it's not common that a provincial court judge is going to make a $5,000 order at the first breach. It normally has to be like a pattern of them not complying with financial disclosure orders. But they do have the jurisdiction to make um, orders for fines of up to $5,000 for non-compliance with court orders or directions of the courts.
Okay. There's a question I think that it was touched on last week, but we'll just put it to you just to see here. Um, So a file that is in Supreme Court that has already had all the asset division, divorce matters resolved, can it be moved back down to provincial court? And would the Supreme information be available to be seen by the provincial court?
So if you've already dealt with a lot of issues in Supreme Court, you could potentially deal with certain issues in provincial court, but it would have to be quite specific, right? So in provincial court, they don't do any asset or property or debt division. So say if it was just for parenting arrangements, then if the other party agrees, then you could start an application in provincial courts, but it will really depend on the position of the other party as well. And the judge in provincial court will not have access to the Supreme Court documents. If you wanted them to have access to the Supreme Court documents, you would have to attach the previous orders made in Supreme Court to your application about a family law matter, if that's how you start your process. But just bear in mind that might then get you a question from a judge. Okay, if you've done everything in Supreme Court, why are you in provincial court? Why not just continue in Supreme Court to deal with parenting arrangements? But it's not like the provincial court is closed to you. You can try. You just have to think about if the provincial court is a better venue for you if you've already done a lot in Supreme Courts.
It's looking like that's a lot of the questions that are relevant to these topics. I know there are a bunch of questions in here, and it's not that we're not seeing them, but again, a lot of these things can be dealt with in other sessions, or they're just a little too specific for cases. So if there's anything that you have legal information questions on, you can certainly obviously email us at our email, or you certainly can see if your questions get answered during these topics. You could write down some of your questions, and at the end of our session on our last week, we do have a Q&A as well. So if at the end you find that your answers are not presented, then you can certainly email us then or ask them during our question and answer period or last week. Is there anybody else that has any questions in the chat that they want to pop in before we sign off for the evening? Give it a minute or so here. Well, while we wait, we just want to say thank you to our speaker, Abisola. We really appreciate you talking on this topic. And yeah, it was really great to have you with us.
Thank you, no problem.
No, definitely. I find provincial court to be quite the puzzle. So going through all this information, like just kind of step by step, it's like, okay, yeah, that makes sense. Okay, now you do this, now you do that. Like, even just going through some of those forms. Because I know a lot of times my work, when it comes to dealing certain provincial court steps, it's like, well, I don't know what form to use. So, especially like the case management order, I didn't know so much about that before, so that was really, really helpful.
Doesn't look like I see any other chats, anything in the chat. So we'll sign off for this evening. Thank you everybody for attending, and we'll see you next week for our next session on Tuesday, October 22nd.
All right.
Thank
Have
you.
a good night, everybody.
Thanks, everyone. Good night.
Probably end the recording too.